Hey, how are we today? My name is Chris Nudo. I am a estate planning and real estate attorney serving the Chicago metro area with offices in Arlington Heights and Elgin, Illinois. And uh, as we approach midsummer here, where in Chicago, that could mean it's 90 degrees with 100% humidity, or it could mean like this morning, a balmy 58. Um, we need to start thinking about preparing for our children who are going to be leaving for college in anywhere from 4 to 8 weeks from now. These are the people in our house that consider themselves adults and want to be treated like adults and still act like children at times. But nonetheless, our world considers these children of ours heading off to college adults. Now, whether you have a first year freshman or a last year senior, or even students who are in graduate programs, today's topic and materials is very applicable. As a matter of fact, even if you have children who are 18 years or older and are not heading away to school, today's topics are very applicable. Now, we're not going to be talking about the typical estate planning topics of wills and trusts because when we're talking about 18 to 25-year-olds, we're talking more about access, assistance, and care in the event of some form of incapacity or disability. And so trusts and wills are more set aside for planning for end-of-life circumstances. And so we won't really be talking about those as much. Today's topic is really going to be focused on the durable power of attorney for property and the Illinois durable power of attorney for healthcare. Now, before we dig deep into our topic, let's get some definitions out of the way. First of all, note that when I talked about these two powers of attorney, I started with the word durable. And that is a very specific term used here in Illinois, and it makes reference to the fact that these specific powers of attorney will survive incapacity. And that is a very unique feature because most powers of attorney, when the person who grants the power of attorney becomes disabled or loses mental capacity, that power of attorney, that grant of power to their agent disappears. It gets terminated. However, if it is a durable power of attorney, whether for property or for healthcare, then that specific power of attorney, that grant of authority from the person does not expire. Indeed, it survives incapacity. And that's why it's very significant. That's why these documents are so incredibly valuable. And that's why we're going to talk about them today. So every parent should consider the fact that there's instances where either A, they may want to get information about their child from their college or workplace or in banking institutions, credit card providers, or there could be instances where immediate healthcare decisions need to be made on behalf of your child, your student, the parent, you as mom or dad, should be the person standing ready, willing, and able to deal with these crises when they occur. Now, let's talk about the state of the world today, specifically as it relates to how does your student's college see your student? Versus how does your student's college see you as mom and dad? Well, all the colleges throughout the country treat our students as if they are these brilliant, intelligent adults who are capable of foreseeing all the potential problems of being an adult and taking all of those considerations into mind and making wise decisions. Now, if you're laughing, that's because we know that students 18 to 25 often, as many good decisions as they make, often will make many bad decisions. And why is that? Well, they just don't have the life experiences necessary to approach life and make good decisions all the time. Now, they could be the smartest students in the entire world. Their limitation is just years on the planet. So I always like to use examples. Your student is at school and having trouble with a professor, and your son, your daughter consults with you about problems with the professor or problems with the registrar's office or problems with financial aid, the admissions office, you name it. Probably not the bookstore, but you get the point. And they say, Dad, can you make a phone call, or can we do a conference call with the financial aid or the admissions office? Because I'm not really understanding what they have to say. Also, they said there's a bill due, Dad, and I'm not really sure exactly the payment method that I should be using or how to use it. Or, I know I have a 529 plan, Dad. Can you help me? Or Mom? So these are real life situations. Now, if you're a parent like me, maybe a little more of a helicopter parent hovering over your kids, not necessarily a healthy thing, but at least I can admit my problems. I feel compelled to pick up the phone, call the admissions office and be like, hey, how can I fix this? And they're going to be like, Mr. Nudo, thank you for calling. Is your son on the line? Because we cannot talk to you about his account without his permission. And I sit there and I say to myself, I don't understand that. Wasn't it me who helped my child get to your school? Isn't it me who has assisted in making sure the tuition is paid? Can't you help me pay the bill for my student, which helps you? And they're like, sorry, Mr. Nudo, we understand that you feel that way, but the laws prohibit us from doing that. So then I have to get my son on the phone and say, son, do you give the school permission to talk to me about paying for your education? And my son, of course, says, well, of course, Dad. And then I can talk to the registrar's office or the admissions office or whoever at the school I need to talk to. Now, you would think that this process could be easier, and it is. So before I get into the super hyper technical legal aspects of it, let me just say every college has a specific form that a parent can sign, which will give you authorization to the information I just mentioned. But my example just focused on a college. Now take this out into broader places, such as banks, such as hospitals, such as doctors' facilities, clinics, financial institutions such as Schwab, Chase, Fidelity. All of these institutions don't have that special form that the college has. So how is it that you can get the proper authority to speak on your child's behalf? And the answer is a durable power of attorney for property. You should have a durable power of attorney for property for your child if they are age 18 and older. Then, in the event that there is some major problem, whether it would be an accident that your child is in, or some debilitating illness, or some form of incapacity that is tragic that your child suffers, and you need to take control of their life on their behalf, this durable power of attorney for property is the tool that you're going to need. It's a very simple, but yet extremely powerful document. When our office prepares this document, it ensures just about that you have the ability to do anything, no matter how obscure. So your son or daughter is into Bitcoin or some form of cryptocurrency that you know nothing about, but yet your child becomes incapacitated and you need to somehow get a crash course into their cryptocurrency and get their account under control. How are you going to do that? Well, only if you have the proper documentation or power of attorney at your disposal will anybody take you seriously. I know it's a far out example, but lots of 18 to 25-year-olds today have dabbled in this cryptocurrency, and these are real life examples that I'm giving you. So the durable power of attorney for property is a statutory form, meaning that the Illinois legislators designed the actual document. You can get it free. That's one option. Google will hand it to you if you Google the Illinois statutory power of attorney for property. However, if you hire an estate planning lawyer, you're going to get a much better document than the standard Illinois statutory form. We enhance this document with many more broad powers and scope so that the document is far more beneficial. So I always tell my clients, listen, you can do the form yourself for free, or you can pay a lawyer to do it, such as myself, and you will get a much better product. Let me be clear. Something is better than nothing. So if you don't want to pay a lawyer to get this power of attorney, please do the free form at the very least. Now, that deals with all the financial and property considerations for your student in the event it is absolutely necessary due to some tragedy that has occurred to your son or daughter. Now, in the same vein, there's times where during these tragedies, immediate healthcare decisions need to be made, such as two different surgeries that have two different potential complications and two different outcomes, and your child is incapable of making these decisions because they are either so sick or so injured that they can't do it. This is where the durable power of attorney for healthcare comes in. And the healthcare power of attorney will give mom and dad authority to speak on your child's son or daughter's behalf for any kind of healthcare decision that is in your child's best interest. Now, if I have a student listening to this right now, your mom and dad is not going to be able to make decisions for you and overrule what you want. This is in the event that you are not capable of making these decisions because you are either so sick or you've been injured so badly that you don't have the capacity to make these decisions. Now, mom and dad are going to step up and take care of you and make these decisions for you. Often, children will be concerned that by signing these powers of attorney, they will lose control of their life because mom and dad are going to start making all their decisions for them. And that is not the case. These documents are for emergency purposes. This is when your child needs help and cannot help themselves. Things in the healthcare power of attorney We'll deal with quality of life issues. We'll deal with medical records, and we'll deal with diagnoses, things of this nature, which can be very time sensitive and important in emergency tragic situations. Included in this is the concept of HIPAA. And if you're not familiar with HIPAA, HIPAA is a privacy act that relates to healthcare. And so if you ever wondered what keeps all your medical records private and not your doctor is limited to whom they can speak to regarding your medical records, these things are all controlled by a body of law called HIPAA. And HIPAA, by the way, is an acronym, but it's essentially healthcare privacy. And in the healthcare power of attorney, we provide what's called a HIPAA release. And that is a very important thing, because your child can grant all the authority necessary for you to make, as a parent, decisions on your child's behalf. But if you haven't specifically released the obligation under HIPAA to keep things private, then the document will fail. But good news, the Illinois statutory form for healthcare automatically is a HIPAA release, and takes care of ensuring that not only is the grant of authority taken place, but also the Privacy Act has been released to mom and dad so that they can get all the vital information necessary. All right, let's pause for a moment, do a quick recap, answer some questions, and call it a day. So my name, again, Christopher Nudo. I am an attorney in Illinois. I serve the greater Chicago metro area. I have offices in Arlington Heights and Elgin. And I work in the fields of estate planning, real estate, and probate. I also do small business work, charities and not-for-profits. And today's topic that we've been talking about is what are the key estate planning needs that are necessary before our kids leave for college. And we've been talking about healthcare powers of attorney and HIPAA releases and durable powers of attorney for property. If you missed my last session, you can watch the video here on Facebook. My last topic was how entrepreneurs and business owners can structure their estate plan. And that was excellent. If you're an entrepreneur or ever wanted to own your own business, that is certainly a video that I can recommend. Every month I provide legal tips for parents, guardians, professionals, and I welcome you to join us here and share our recordings with your friends, colleagues, and family. Now, I know a lot of you have many questions, so let's dive right in. First question we have today is, if a child has a disability, are there any documents that are important to create for my school's records? Yes. Excellent question. And that is exactly the question that is answered with the Illinois durable power of attorney for property. And so have your child prepare or have prepared for your student a Illinois statutory power of attorney for property, and that document will assist you in getting your students' records. As I mentioned, every college does have another form that they provide for specifically student records. And so if you are only looking for student records, then you can use the schools form. Just contact the admissions office and they should be able to help you. But my recommendation is to have the broader, greater authority form, which is the power of attorney. Second question. What is the best place to what is the best place to save or store legal documents for access in the event of an emergency? Excellent question. So where should you store these documents? I recommend taking a redundant approach. First of all, I believe the originals of these documents should be kept in an incredibly safe place with the parents. And so parents, wherever you keep your most valuable documents is where you should keep these powers of attorney. I recommend a waterproof safe. They are not very expensive. You can get them just about anywhere, and they will waterproof and fireproof, and that's the best thing. But I also recommend that you scan these documents and you keep them in a PDF format. And that you store these things on cloud drives, such as a Google Drive or a OneDrive or whatever drive you have that is a cloud-based drive. And finally, storing these documents in multiple places is an excellent idea. So if your wife is very astute with Google and likes to use Google Drive, and you are a Microsoft OneDrive guy or some of the above, then each should have a copy of these documents readily accessible in a moment's notice. Thank you. That was a great question. Our third question today is, if a child is a minor heading to college, what legal protections are in place? So if your child is a minor, let's define a minor. A minor is under the age of 18. Then you as the parent still have all the guardian rights, responsibilities, and ability in which to get all the information and make the decisions that you need to make on behalf of your student. However, very few 17-year-olds are heading off to college. So until they turn 18, mom and dad, you have the necessary authority governed because they are under the magic age of 18. However, once they turn 18, all the information and topics that we discussed today are vitally important. Our fourth question for today: how do healthcare treatment or emergency decisions change once your child becomes an adult? Excellent question. So the question is, when your child is 18 or older and they have an accident with a severe injury or an illness that where they need acute medical attention, mom and dad, what say do you have in this process? And the answer is you get say number 2 and 3, because child gets say number 1. They are an adult. They get to make their decisions. Now, what happens if they cannot make the decision because the illness or injury is so acute that they're just not capable? And the answer is, this is where the healthcare power of attorney is the document necessary to present to the hospital, physicians, or treatment center so that you can act on your child's behalf. Our fifth question today: how much does it cost to work with an estate planning attorney? I always love that question, and because the answer is it depends. Today's topic is a very inexpensive topic. Powers of attorney are relatively inexpensive, free if you want to prepare them yourselves. I always recommend that you hire a professional to prepare them, especially the power of attorney for property, because we prepare a more verbose document than the standard statutory form. But working with an estate planning attorney is a process of understanding what documents are necessary, not one size fits all, and taking a look and putting together a proper plan to meet the goals and objectives for your family. That is also financially sound for you. So, what's the difference between working with a lawyer and doing the paperwork yourself? Well, number one, when working with a lawyer, you're going to have the confidence of knowing that it was prepared correctly and executed correctly. When you prepare it yourself, listen, you're going to save money. No question about it. Us lawyers don't work for free, but you won't have the assurance that it was executed and prepared properly. Now, I have encouraged on this video today, and it's very rare that I do make this encouragement, but the healthcare power of attorney is a document that one can do on their own if they choose. And just pick up the Illinois statutory form, healthcare power of attorney, and walk through it. It requires witnessing and notary. But that is a document that, if you choose, is probably the easiest of the documents that you can prepare on your own. The Illinois statutory power of attorney for property, again, available for free. You can prepare it yourself. However, if you want a more verbose, a more thorough document, I recommend hiring an estate planning lawyer for the property power of attorney. By the way, just a quick aside, I do not at any time ever recommend that you prepare your own will or living trust. I know there's software packages out there that claim to be able to do it. I can just tell you that it is a bad idea. We have a saying around the office here: friends do not let friends play stunt lawyer. We do not promote people pretending that they know what to do. What we do is a very specialized area of the law. We have lots of training in it, and that training ensures that it gets done correctly for your family. Do you offer virtual appointments or on-site visits? And the answer is yes, I do everything. You want a virtual appointment? Fantastic. We'll queue you up here on the computer. You want to come meet me in Arlington Heights or Elgin, or we need to meet at some other location? Yes, we travel. We do what is necessary for the convenience of our clients. Remember, we work for you. And where can I contact you and set up a consultation? Well, right on our screen here, we're going to have our addresses and phone number and email address and all the contact information on the lower third of the screen. And or you can visit us at our website, which is www.nudo.net. You can email us, call us. I always like to say, send smoke signals. I might actually get those also. Listen, it has been so much fun spending the morning with you here, talking about how to take care of your children, 18 and older, making sure that they have their proper powers of attorney in place before they head off to a really exciting time in life. Parents, encourage your son or daughter to work with you to get these documents in place. They will give mom and dad a peace of mind, as it is a very scary time of life when you send your son or daughter out for the first time to school. They are branching out as adults. They are excited. Let's just make sure we take some proper care and have the proper documents in place in the event of some sort of emergency or tragedy. So again, very nice spending the day with you. You guys have a wonderful day, and God bless.